Hello, everyone. My name is Magali Contardi. I'm a PhD candidate from the University of Alicante, working under the supervision of Professor Manuel de Santos. Furthermore, I'm a researcher in comparative private law at the Scuola Superiore Sant'Anna, where I deal with projects in the field of intellectual property and regulation of data. As an IP lawyer, I had the opportunity to practice in many aspects of my research, and practice is often the source from where my interest in further research arises. My today's contribution, entitled AI Medical Devices in Time of Emergency, What Should Patent Law Do to Take the Best Out of Them, partially stemmed from my research thesis, which focuses more broadly on the interplay between regulation, patent, artificial intelligence, and medical devices. The use of artificial intelligence in healthcare has given rise to myriad of new e-health medical devices. It has also improved the opportunities and capabilities of the so-called traditional hardware devices. The COVID pandemic has been the testing ground of benefits and flaws of such a revolutionary landscape. As you may see, countless are the examples of medical devices coupled with artificial intelligence and purely AI medical devices that have assisted in tackling the pandemics. They provide medical healthcare, helping detecting symptoms, or give treatment recommendations. Not only, AI medical devices are already being used for diagnosis and for treatment of other diseases. But their uptake may be challenged. As multiple real examples show, these devices may be very opaque in regarding their inner workings. This opens the door to immoral uses. In turn, AI medical devices may be even programmed for such a result, for instance, to privilege certain population of others when recommending a treatment. The availability of patent rights notoriously incentives research and development of this kind of technology. In this sense, the EPC envisaged an exception at Article 53A, which prevents the patentability of inventions that lack morality or are the public compliance. In the European Union, ethical compliance of patents is required with reference to biotech inventions. Also, the TRIPS agreement provides contracting members the possibility to refuse patent applications on grounds of morality. Lastly, some references to morality are already included in the Paris Convention, but with regards to refusal of trademark applications. The reason of this provision is linked to ethical rationale, but as it will be seen, this rationale is not so unrelated to the utilitarian premises underlying patent incentives. The European Patent Office has ruled in few cases about morality and patent law. Although these cases are not related to AI, but to biotech, their analysis is useful to shed light on how morality and other public exception should be interpreted. In the Oncomouse case, in assessing the morality exception, the Technical Board of Appeal of the EPO performed a cost-benefit analysis of invention, animal suffering versus benefits in treatment of cancer. In the relaxing case, in upholding the patent, the board concluded that the exception envisaged under Article 53A should be limited to those extreme cases in which the public will regard the invention as so abhorrent that the grant of rights will be inconceivable. In plant cells case, the abhorrent standard was confirmed, the board also adding that morality covers exploitation, which is not in line with conventional accepted standard of conduct pertaining to this culture. Further, in euthanasia case, the board held that the concept of ordre public covers the protection of public security and the physical integrity of individuals as part of the society. When assessing the morality exception in Bruxelles, the enlarged boards of appeal took into account the full technical teaching of the application. Called to rule on this invention, the Court of Justice of the European Union interprets use in commercial exploitation as covering also use in scientific research. Finally, the cultural stem cell case is also a relevant precedent, as it confirms that although the EPO is not bound by European Union law, these sources represent a supplementary rule of interpretation of the EPC. Again, this background applicable today to biotech invention, the question is what patent law should do? Some suggest doing nothing, arguing that patent law is not the right venue to deal with morality issues. Whether the commercial exploitation shall be prohibited or not on ground of ethics should be left to other regulatory frameworks. However, this could have chilling consequences in the market signaling effect of patent law, resulting in the allocation of resources in unwanted inventions. In other words, expelling the moral debate from the patent system would ignore its key function, promote and reward innovation useful to our society. In my work, I suggest instead recalling the economic importance of ethical compliance and fundamental values of our society as a way of pointing out what kind of invention the patent system should promote. This approach is consistent with the case law of the EPO as regards the interpretation of morality-based exception, as already seen. The approach is also in line with the position taken by the European Union in several documents and communications. This could be done by incorporating in the EPC implementation rules interpretative criteria in line with certain provisions enshrined in the AI Act or principles laid in the ethical guidelines for trustworthy AI, and by strengthening the sufficiency of disclosure requirements to attach the morality assessment to the above referred interpretative criterion. Thank you very much for your attention. Your feedback is very much appreciated.